Happy evening, sir.
Happy evening, Navneet.
Sir, Supreme Court has given bail to Arvind Kejriwal. Even though he got bail, why he has resigned as Delhi CM, sir?
Yes, Navneet. If you see, Arvind Kejriwal has got bail in two cases. One is Enforcement Directorate has filed a case against him with respect to Prevention of Money Laundering Act 2002, wherein they have registered ECAR in the year 22nd August 2022. In ECAR number HIU 2 bar 14 bar 2022. That is the Enforcement Directorate case, that is ECAR document number. Based on this, Enforcement Directorate started investigation on Delhi liquor policy case. CBI registered a Delhi liquor policy case somewhere in 2022. From then on, the investigation was progressing. In fact, Manish Sisodia, Deputy Chief Minister of Delhi, was arrested. Subsequently, many other people connected to the Delhi liquor policy case was also arrested. But however, Arvind Kejriwal was arrested only on March 21, 2022, almost near to the elections. And he was arrested after issuing 9 summons by the Enforcement Directorate. But point to be noted here, Arvind Kejriwal was arrested on March 21, 2022. Subsequently, he was granted an interim bail just before the election in the month of May. That is on 10th May 2024. And the point to be noted here, he got only an interim bail. Subsequently, he has to surrender on June 1 after the election got over. When the interim bail was given by the Supreme Court on 10th May 2024, there are various conditions which were stringent conditions which were provided as part of that order. But point to be noted, after Arvind Kejriwal surrendered on June 1, 2024, he moved his bail application on Enforcement Directorate case, that is under the Prevention of Money Laundering Act 2002. Again, he got bail on July 26, 2024. So his bail got regularized. While the bail got regularized, it is very important point to note, when the bail was provided on May 10, 2024, there were stringent conditions that were levied as part of the interim bail, wherein they said he shall furnish bail bonds to the tune of 50,000 rupees with one surety of the like amount to the satisfaction of the jail superintendent. 2. He shall not visit the office of the Chief Minister and the Delhi Secretariat. He shall be bound by the statement made on this behalf that he shall not sign official files unless it is required and necessary for obtaining clearance, approval of the Lieutenant Governor of Delhi. He will not make any comment with regard to his role in the present case, and he will not interact with any of the witnesses or have access to any files connected with the case. This was provided as part of the interim bail. But these conditions were not levied when the regular bail was granted with respect to Enforcement Directorate case. In that case, para 86 is a very important paragraph, wherein they said the observation of the Supreme Court was in the regular bail that was granted on July 26, 2024. In 86 paragraph, they said, we are conscious that Arvind Kejriwal is an elected leader and the Chief Minister of Delhi, a post holding importance and influence. We have also referred to the allegation. While we do not give any direction, since we are doubtful whether the court can direct an elected leader to step down or not, function as a Chief Minister or as a minister, we leave it to Arvind Kejriwal to take a call. Larger bench, if deemed appropriate, can frame questions and decide the condition that can be imposed by the court in such cases. So from this paragraph, what we should interpret is that the court did not say or court did not provide any condition with respect to Enforcement Directorate case, that is Prevention of Money Laundering Act case, wherein Arvind Kejriwal got the bail in July 26, 2024, or even in CBI case where Arvind Kejriwal got the bail, there were no stringent condition. But what point to be noted, when the interim bail was granted, there were stringent condition, and accordingly court observed in the regular bail order that even though Arvind Kejriwal may not be asked to step down by this court, larger bench may decide if it is appropriate. Accordingly, Arvind Kejriwal, after coming out in bail in both the Enforcement Directorate case, that is Prevention of Money Laundering Act case, and also CBI case, Arvind Kejriwal voluntarily resigned as the Delhi Chief Minister and appointed Adishi, his own party leader, as a Delhi Chief Minister. The point to be noted here is that politically the move taken by Delhi Chief Minister Arvind Kejriwal to step down from the Chief Ministership is seen as a biggest political move. The reason is, with the politically, if you see, he has already won the sympathy of many people in the country. And beyond this, he also wants to step down to concentrate on the party affairs and party work so that he can strengthen the party for the next year election. So this is seen as a strategic move by many of the political analysts and even people who see his move, say that it is very important at this juncture for him to meet the people and win the confidence of the people. And many people say this is an Agni Pariksha that he has taken, wherein until he becomes the chief minister for the next term, he wants to be with the people and build the party with the people so that his party can make a clear sweep in the forthcoming election in 2025. Many people also say this is a strategic move to build consensus with the opposition parties so that he can build a strong alliance for 2028 MP election. So Arvind Kejriwal's move to step down from the chief minister, even though maybe voluntary, but it is seen as a strategic move in the political circles. So I'm sure that Arvind Kejriwal, using this opportunity, will strengthen his party. And of course, he has to face these cases in the court where charge sheet has been filed and subsequently trials will happen. He has to manage with these cases and parallelly he has to work for the party affairs. The point to be noted under the law, as per the Representation of the People Act 1950, there is no bar for Arvind Kejriwal to continue as chief minister. It is not because of the Representation of the People Act, because Representation of the People Act does not bar accused or on any legislative member on whom accusation could be there or charges could be there. It only says people who are convicted cannot continue as a member of the Legislative Assembly or a member of the Parliament. Accordingly, the disqualification to be a minister or chief minister attracts. But whereas Delhi Chief Minister Arvind Kejriwal, as he steps down today, we have to understand that Representation of the People Act 1950 does not bar him to be the chief minister. So accordingly, it is a voluntary exercise of stepping down from the chief minister, which Arvind Kejriwal has taken up to build his party. So accordingly, it is only a political move to build his party, and no act or no enactment prohibits him to be a chief minister of the Delhi.
So we can doubt all these as a political drama, is that right, sir?
Definitely, many people categorize as a political drama, but what we can see as such, because that's the opinion of the many people, seeing as a political drama. But what we have to understand, this move by Arvind Kejriwal is only for the purpose of strengthening his party so that he can sweep the election in the forthcoming election, because there is a kind of a sympathy wave on him because he's almost detained in prison for almost 6 months. So I think this is a step that Arvind Kejriwal is doing to strengthen his party.
Sir, will ED take further action on this case?
Definitely good question, Navneet, because Enforcement Directorate, somewhere in the month of July, they filed a supplementary charge sheet where they made Aam Aadmi Party as one of the accused. A point to be noted here, generally political parties are not made as an accused in any of the cases. But this is the first time Enforcement Directorate brought AP, that is Aam Aadmi Party, as an accused, the party name itself as an accused, as part of the supplementary charge sheet. And the concept that they are trying to drive for the first time is, if Aam Aadmi Party is made as an accused, then doctrine of vicarious liability will apply. So many of the party members who are important functionaries of the party who could be involved in this Delhi liquor policy could be arrested, or even investigation can be carried on them. So accordingly, AP being made as an accused and accordingly a supplementary charge sheet is filed, there can be possibility under section 50 of the Prevention of Money Laundering Act 2002 that summons may be even sent to many of the party functionaries of the Aam Aadmi Party to investigate on this matter. But however, point to be noted here, Enforcement Directorate bail order and CBI bail order both has to be looked into for the purpose of observation of the Supreme Court. Supreme Court said CBI arrest was an insurance arrest. Similarly, if you see Enforcement Directorate, when they granted bail, so they spoke about need and necessity of arrest. And with respect to section 45 of the Prevention of Money Laundering Act, which is about the bail provisions, section 45 of the Prevention of Money Laundering Act has twin conditions, which is stringent condition. So accordingly, as Arvind Kejriwal has got the bail from this both the cases, CBI as well as ED, and even Manish Sodhi has got the bail. So accordingly, even if somebody is going to be arrested, then already there is a precedence of judgment of the Supreme Court with respect to this matter. So accordingly, their bail may also be decided based on the precedence that is existing in this case. So accordingly, there is a possibility for Enforcement Directorate, based on the need of the investigation, to summon many of the other leaders of the AP party, because AP itself has been made as an accused. So definitely AP leaders have to face this case in the court. But however, they have a constitutional right to defend it through various legal remedy. I am sure that AP leaders will do this in the days to come.
Thank you for your valuable time, sir.
Thank you, Navneet.